Hi, Sam. How are you?
Hi Mariana, I'm good. How are you?
Very good. Here we are again.
Mm-hmm. Welcome back to Tea with Noli IP. Today we're talking about copyright.
Very nice. Very nice. So here we have a presentation that Sam had prepared for us, and I know you have some questions about copyrights, right?
Yes,
Thank you, Sam, for all the work that you're doing with the digital marketing of the firm. You're doing a fantastic job.
no problem. So my first question is, what are the differences between a copyright, trademark, and a patent?
I'm sure that you remember that you asked me the difference between a patent and a trademark when we were talking about trademarks. So the difference is that the copyright protects the original works of authorship. Think about when you read a book, the information that you're reading in that book, it's copyrighted. Or if you listen to a song, I know that you're a musician, so when you listen to a composition, it's copyrighted. The author that created that original work of authorship is the author of the copyright to that song. The same with movies, pictures, and other things, as long as it's an original work of authorship. And it has to be fixed in a tangible form.
That makes sense. So how do you create a copyright?
So when you're thinking about a song or when you're thinking about a book, the copyright does not exist yet. The copyright exists when it is fixed in a tangible form. So for example, when you write a poem or when you paint the painting, that is when the copyright is created.
Okay. What cannot be protected by copyright?
And I guess this question is linked to the first question that you just asked me about the differences between the trademark and the patents. At the end of the day, Sam, we're talking about the different intellectual property rights, and different intellectual property rights protect different things, different aspects. When we talked about the trademarks, I remember sharing with you that the trademarks function as a source identifiers. They let consumers know where the goods or the services come from. And by knowing that they come from a particular source, the consumer knows that those goods and services are of a certain quality. The patents, on the other hand, protect an invention. If it is a utility patent, it protects the functionality of your invention. If it is a design patent, it protects the ornamental features of that invention. The copyright protects the original work of authorships. It doesn't protect names because those are protected under trademarks. So no names, no slogans, no words, no designs. It doesn't protect an invention because an invention is protected by a patent. Does it make sense?
Yeah, that makes sense.
Okay. And of course, it has to be original. If it's something that it's not original, it's not protected under copyright.
Yeah. How do I let others know about my copyright?
This one is a very important question because you do want to put other people on notice. And the way that you do that is that you have three elements that your copyright notice needs to contain. The first element, it's either the word copyright or the copyright symbol. You probably have seen it. It's the C in a circle. Have you ever seen it?
Mm-hmm.
So that would be the first element, the copyright or the copyright symbol. Then you need the year that the copyright was created, and then you need the name of the owner of the copyright.
Okay. Should I put others on notice about all works that I copyright?
It's very difficult to put everybody on notice of everything, but it's important to include it because once you do, there are many benefits that come with putting third parties on notice that you're claiming your intellectual property rights to a certain work. All your works, it may not be feasible, but you do want to put them on notice of the works that you want to claim your exclusive rights to.
Okay. So how long does copyright protection last?
You know, it depends on many factors, depending on whether it's been published, when it's been published, but I can tell you that as a general rule, if it's been created after January 1st, 1978, it typically lasts the life of the author plus an additional 70 years.
Wow. Can I transfer my copyright to others?
Yes, you should be able to freely transfer your copyright to others. So for example, let's say that you compose a song and we copyright it, and then you want to either license it or sell it to a recording, to a label, because you know you really are just the creative behind this original work of authorship, but you're not planning to exploit it further. You can easily transfer your rights.
All right. What is the difference between copyright creation and copyright registration?
Copyright creation is that moment when you put in paper the poem, when you fix your original work of authorship in a tangible form, when it's in writing, when it's something that it's tangible. That's when you create it, that moment. The registration, on the other hand, it's when you register, you file for an application with the United States Copyright Office, and then it is a very short process, but it's still a process, and you register with the US Copyright Office.
Okay. What are the benefits of copyright registration?
There are several benefits, just as when we talked about trademarks. When you do register your copyright, because it's protection at the federal level, you're able to bring infringers to federal court if you have to sue them for infringement. There is a presumption that the individual that or the company that shows us the owner of the copyright is in fact the owner of the copyright, and the third party will have to challenge it and prove that that is not correct. You are able to collect attorney fees in case of a dispute or possibly statutory damages. So you put on notice third parties that you're claiming exclusive rights to that original work of authorship. So if you ask me, it's highly recommended that you protect your copyright and you register with the US Copyright Office.
Okay. Can I file one copyright application for multiple works?
Yes, and we continue to talk about music because I know that you're a very talented musician. For example, let's say that you came up and you composed several pieces and you kept them secret. You didn't publish, you didn't give, you didn't give a concert, so they're unknown. We could file, when certain conditions are met, we could file one single copyright application to several of your works, several of your original work of authorships. That would be each one of these songs. So we can, as long as it's the same author, and there are several works that have not been published, for example.
That makes sense. Thank you for talking today and answering all my questions about copyright.
You're very welcome, and I'm excited to see you next week.
Yep.
Bye, Sam. Bye.